We don't have time for further questions at this point, so we do have time for further debate. I recognize the member from Oshawa.
Thank you very much, Speaker, and I am very pleased to stand on behalf of the fine folks from Oshawa and bring their voice and my own to this debate. We're debating Government Bill 245, named the Accelerating Access to Justice Act. We've had some interesting conversations so far in this space. I am going to raise a few flags and concerns brought to my office from the folks who might avail themselves of legal aid, who have found themselves actually quite challenged because of either the cuts or challenges because of the pandemic, which we know and have heard has challenged many folks to be able to access the services and justice that they deserve. So first, I'd like to commend my colleague from Brampton East, who serves the official opposition as the critic for the Attorney General. And I wanted to read one of his quotes that he eloquently offered yesterday in the House, and I thought it would set off the debate nicely. He said, quote, "These halls have an opportunity to either create laws that are regressive, create laws that lack equity, that lack justice, or create laws that create justice. We can either make a decision to bring in different forms of legislation that will create more liberty and more freedom, or less liberty. We can create legislation that can liberate, or create legislation that can keep people within either economic or social repression or bondage, or other forms of states that are not ideal for living their ideal lives." End quote. I liked that. It resonated, and it made me think of a lot of my neighbours in Oshawa. There are a lot of folks in Oshawa and across many of our communities that are living in the margins, that are doing their darndest, pandemic aside, which has exacerbated their needs, but who do deserve many things, including fair and unencumbered access to justice. So one of the things that I'd like to start talking about is a big part of this government legislation, which is a big piece of legislation. It's 75 pages. It's 11 schedules. Most of those schedules I don't have flags or comments on. But there are some pieces in there, and one of the big pushes from this government, and we see it across the board, Speaker, is digitization. So many of us are appreciating the new and glorious ways of communicating. It is remarkable that I can play virtual board games with my family that lives across the province. There are all sorts of cool things we've discovered during the pandemic that technology has afforded us the opportunity to do. However, there are many people who live in the margins, and many people that we know and are our neighbours, and many that the official opposition members serve in their community offices or virtually right now or on the phone, that do not have access to the tools that they would need to avail themselves of these new justice tools. So while we're putting technology at the forefront, I wanted to share something that comes to me from the Durham Community Legal Clinic. I had reached out to them, and man, do I ever appreciate the work that they do. Our office has them on speed dial. Like many of us, the agencies in our communities do unbelievable heavy lifting and caring and very remarkable work. So this is something about, or this is something called Access to Justice Doesn't End Online. So, quote, "In 2019, the Durham Community Legal Clinic, or DCLC, whose head office is in Oshawa, launched the Durham Access to Justice Hub, an interagency and innovative initiative to promote access to justice. However, soon after this, the province of Ontario imposed cuts of $133 million to Legal Aid Ontario, which sent the entire clinic system into a tailspin. Although Durham Community Legal Clinic effectively observed only about 1% of a cut on their total budget, the effects were devastating, given the thin budgets that clinics operate on and the interdependence of clinics on others in the system who had far deeper cuts imposed on them. Despite these challenges, DCLC was well prepared for the COVID-19 pandemic, given that it was already looking into improved workplace processes and use of technology. Within days, the clinic was serving clients remotely and able to appear at hearings virtually. However, there were some significant limitations to the services that the clinic could provide. Quote, although we assume that all Ontarians have easy access to the internet, we know that for some low-income residents that's simply not the case, said Omar Haredai, Executive Director of DCLC. Quote, remote-based access to legal services to some of those most vulnerable members of our society is still elusive, even with improvements to process to our legal system, end quote. Given the widespread health concerns during the pandemic, DCLC supported the creation of changes for small estates in Ontario, which was announced on February 12, 2021. These changes make it easier for low-income Ontarians to access small estates and their families. The changes that were introduced in Bill 161 to allow for remote notarizations and commissioning also meant these services could be provided over a broader geographic area. Further amendments in Bill 245 enhanced the remote provision of services. DCLC implemented 2 significant technological changes during this period: an automated will creation system to reduce the administrative burden in creating wills, and a blockchain-based identity verification system used in preventing fraud and abuse. However, for many low-income Ontarians with limited internet access, this simply isn't enough. Quote, community legal clinics are strategically situated across the province and already provide effective and efficient legal services to their communities, said Haredai. The province could improve service delivery further by improving stable and increased funding to clinics and allow them to play a larger role in our justice system. He points out that for many low-income Ontarians, these remote-based services and virtual hearings still create a significant barrier for accessing the justice system. Many of them would be willing to attend a clinic in order to participate in their legal proceedings, but the clinics require greater provincial support for them to do so. Basically, Speaker, all of that to say that Bill 245 is not taking particular note of the needs of low-income Ontarians. They're not. There are barriers that are being created here. I will admit that there are some, there's some streamlining happening. There are some different opportunities. However, if you're letting folks fall further through those gaps and not taking that into consideration, you are doing them a disservice and you are accelerating their fall away from the justice system, not allowing them to access. Also, Speaker, this on the heels of the fact that the changes to the Residential Tenancies Act in 2020 allows for the expedited evictions without a hearing in certain circumstances. So, the resulting flood of evictions have not only increased the risk of homelessness in Ontario, but they've also strained even further the resources of these community-based legal clinics. Anyway, this government hears it all the time, and then some of the members on the other side said that we're reaching out to our community. That's where we're reaching, and I would recommend that all folks do the same thing to hear about what these decisions will actually do and how they will affect people out in their communities. Speaker, we've talked about the Judicial Appointments Advisory Committee. We've talked about the fact that while this is a modified, I'm going to use the term modified proposal to what had originally come before us, there are still questions around that, so that is something that different stakeholders have different opinions, so we'll watch. And I hope that it does lead to the diversity that the government has talked about. I hope that we do not see that there is the potential for partisanship or politicization. That's Schedule 3. I will delve into Schedules 8 and 9, and while I listened to the member from Durham and was actually quite interested to learn a bit about the rules around marriage and wills and whatnot, I'm not going to go further into that. I found that interesting enough, but I will speak a little bit about Schedules 8 and 9. And I think the general understanding, like I said before, and this speaks again to the digitization, the broader world will appreciate different technological tools. However, while it may benefit many, it is a reality that many low-income Ontarians don't have that same access to internet or remote technology. They may effectively be prevented from accessing those legal tools. So unless there is, that help from local community legal clinics, they're on their own. And those community legal clinics have to be funded. They have to be prioritized, especially if you're going to download all of this stuff onto them. The legal clinics that currently have the video conference technology or capability, they're going to bear the brunt of this. They're going to have everyone turning to them, and I'll get to that in a second. Speaker, I wanted to share, and the names have been changed, so her name is not really Emily, but for all intents and purposes, I will use the name Emily. Emily is a 72-year-old woman who was recently widowed. Her spouse died in 2019, not long before the start of the COVID-19 pandemic. She had a working life and has had health concerns and is now on the ODSP benefit program. At the end of the month, there's not too much left over. However, since the pandemic, or during the pandemic, Emily was concerned that her 3 grandkids may not receive her inheritance if anything were to happen to her. She had not made a will. She had a bit of money saved, and she thought it might be helpful to her grandkids down the road. She does not know how to make a will, cannot afford a lawyer based on her limited means. She's also very concerned that if she sees a lawyer, that the amount of money that she has saved will be spent on the lawyer instead. So back in December, she reached out to our local Durham Community Legal Clinic to see if she could get some help. They were able to, despite the funding cuts that had been imposed by the provincial government, and they had originally had to stop providing wills, they had resumed some of the services with help from some of these technological tools. And for Emily, these are tools that actually would have been awesome. They would have been very helpful for her. They could have assisted her, but she didn't have any internet at home. And rather than trying to do the will herself, she was able to come in to the clinic in person. She could receive assistance, totally socially distanced, and was served by the clinic staff. So fortunately, she was able to get a will. She was able to leave the money for her 3 grandchildren, and also put into place a power of attorney. However, the point is that the changes in Bill 245 would not be enough for Emily, because Emily still needed more personalized services in order to arrange her affairs. And we have to ensure that folks like Emily, and there are so many folks out there who don't have access to reliable internet or can't afford a lawyer or what have you, that they still are going to be able to access the services and supports of a community legal clinic. And again, as we've heard over and over, in this bill called Accelerating Access to Justice, there is no mention of legal clinics, certainly no funding. There isn't support in this bill. Speaker, I'm going to delve a bit into Schedule 6 because I have the opportunity to serve the official opposition. Really, I have the opportunity to serve the province as the official opposition critic for infrastructure, transportation, and highways. And I found Bill 245, Schedule 6, quite interesting because it kind of fits with what we've seen from the Conservative agenda of developers first. And I wanted to raise some issues around the amalgamation and the tribunals. So first of all, the Canadian Environmental Law Association has said that a better name for Schedule 6, Speaker, would be the, quote, Denial of Access to Justice Act, which tells you where I'm going with this. And it enacts the Ontario Land Tribunal Act, which merges 5 tribunals within the current Ontario Land Tribunals cluster into a single tribunal called the Ontario Land Tribunal. So the ones being merged are the Local Planning Appeal Tribunal, the Environmental Review Tribunal, the Mining and Lands Tribunal, the Conservation Review Board, and the Board of Negotiation. So I tell you that to tell you this. You have a lot of experts. You've got a lot of folks who do have different realms of expertise. The folks who deal with, local planning and land transfer, they know what they're doing, and that is their area of expertise. The folks who deal with environmental review issues are experts in that area. So I worry that if you're going to have this big amalgamated tribunal, that we're going to lose some of that expertise. Might makes right, so to speak. If you're going to have that many cooks in the kitchen, how long will it be before the environmental voices are no longer in that kitchen? It's a real question, and it's a very real concern. By the way, as of February 19th, and I would love for the government to stand and say, don't worry, we've got this covered, but as of February 19th, this hadn't been reported to the, what am I trying to say? Hadn't yet been gone before the Environmental Bill of Rights. Thank you. Hadn't been reported yet, so that's a shame. Hopefully that'll be remedied. So, Speaker, I have a couple of concerns that are really nitty-gritty here, but I'm going to get them on record, and again, I'd love for someone to explain. So the tribunal, this amalgamated tribunal, and we know how important tribunals are. They're supposed to be faster, more efficient. They're oftentimes where people interface with the legal system, and they go to specific tribunals with very specific issues. But in this case, the tribunal may dismiss a proceeding without a hearing if the tribunal believes the proceeding has no reasonable prospect of success. So does that mean that the person with the most money in the game wins? Does that mean that if you have a big, you've got a big corporate body and you've got some neighbor who says, hey, I don't want this developer to get away with this, or I have a concern with this, and the developer's got the bigger pockets, does that mean that they win, since now it's based on no reasonable prospect of success? Because my understanding is before, or currently, it only allows these kind of dismissals for proceedings outside the tribunal's jurisdiction or that are frivolous, vexatious, or commenced in bad faith. Also, Bill 245, and I want to know where the accountability is here. Bill 245 removes the right to a judicial review or an appeal when the tribunal breaks its own rules or misuses its discretion. Gosh, I hope it wouldn't do that, Speaker. Unless someone can show that the noncompliance caused a substantial wrong, but removes the right to a judicial review or an appeal when the tribunal breaks its own rules or misuses its discretion. So accountability would be where? Like under the couch cushions? Like I don't like that. I don't trust that. Some housekeeping points. Okay, so this one I read as no more due diligence, but Speaker, you're welcome if you'd like to tell me what you think. So it also repeals certain statutory duties and requirements that currently apply to the Board of Negotiation of the LPAT under sections 27 to 29, including the mandatory inspection of land being expropriated. So no longer do we need a mandatory inspection of land being expropriated. No longer do we need timelines for the service of appraisal reports. No longer do we require a written record of oral proceedings. Could you imagine if they pulled that in this House, that we don't really need Hansard anymore? The requirement of written reasons for decisions, and the authority to publish reports of significant decisions. So am I reading that correctly? No more due diligence, no more written record required. I have no more transparency or accountability. Man, there's so much to say, and I am watching the clock and realize that I'm out of time. But again, you've got a whole agenda that we have seen that puts developers at the centre of the decision-making in this process, or in this province, with limiting consultation and participation, politicized land use decisions, violations of the Environmental Bill of Rights. All of this is what we have seen to this point. And this is something that is just tucked in this bill. And yeah, sure, there's stuff in here that's not the worst. Some things seem to be good. However, we do have things that I don't know how we overcome unless you take them out and fix them. So let me know if you're planning to do that. But again, what we need, Speaker, we need a real improvement to accessing justice. We need to make sure that people are at the centre of this. It is people who deserve access to justice. Thank you.
Thank you. We have time for questions. First question to the member from Flamborough-Glanbrook.
Thank you, Speaker. Speaker, when the proposal to allow virtual commissioning and notarization of documents was first put forward back in Bill 161, the opposition voted against it, even though it would improve access to justice for Ontarians. This is something the opposition often speaks about, but rarely do they ever actually support. Making the emergency order on virtual witnessing of wills and powers of attorney permanent through legislation would make Ontario a leader in Canada in this field by allowing hard-working Ontarians to save the time and expense of a trip to the lawyer's office. Will the member support increasing access to justice for Ontarians, particularly those living outside of urban centres who have access to fewer law offices?
To the member from Oshawa to respond.
Yep, thank you, Speaker. As I had read from the Durham Community Legal Clinic, I spoke about Bill 161. Grateful that the member was paying close attention to that. However, I will say that what I've said clearly is that while many people are going to applaud and be grateful for and utilize the technology and the technological tools, you're leaving folks out. There are gaps that are being created, and the legal clinics are saying this, that if we don't put the funding in to support the legal clinics who are going to be at the front lines of this, they're going to bear the brunt of this. Are you increasing the money that will go towards the staffing costs to those clinics? Are you helping them pay for the computers?
Response, please.
Where's the money coming from to support the legal clinics to do this work, to make this system work for everyone?
Thank you. Next question, the member from Toronto Danforth.
Thank you, Speaker. Speaker, it's a pleasure to have a chance to ask this question. To the member from Oshawa, you talked about people who are going to have difficulty with the new digitized or more digitized justice system. You talked about their lack of access to the technology, the equipment, and perhaps even the knowledge. Could you expand on why you see this as such a substantial problem and what, in fact, the government could do to address it if it was serious about making sure that everyone had adequate access to the justice system?
Member from Oshawa to respond.
Yeah, I appreciate that a lot, because I think that as the government is downloading this responsibility onto the front lines, in this case the legal clinics, some things to factor in, that it may be dehumanizing for clients. It's easier for adjudicators to dismiss clients without meeting with them face-to-face. It may become more difficult to get those in-person hearings if the default is video or telephone hearings. There's going to be an increased need for staffing because more people will turn to this. I think that the requirements for folks in terms of computer access to technology, is this going to happen at libraries if it can't happen at a clinic? What about bad weather or a holiday when the clinic is closed? What are people to do, and what do those structures and supports look like? I think that the positive about more people perhaps with disabilities that wouldn't be able to access the clinic, there are some positive things, but if you don't fund it, if you don't structure, if the government doesn't structure it properly, we're going to have people further marginalized and left to do this on their own without the supports if they cannot work with the legal clinics. That wasn't mentioned. The clinics weren't mentioned in the bill.
Thank you. Next question. The member for Peterborough, Northumberland South.
Thank you, Speaker, and thank you to the member opposite for her speech. Speaker, my question is specifically on a transparency piece. Currently, the JAC doesn't publish diversity statistics. I know that the application form does allow the applicant and to self-identify, which we know is already in that application form. And under the Accelerating Access to Justice Acts, it proposes making the JAC mandatory that they publish detailed diversity statistics. And I think that by collecting and reviewing these statistics, we'll have a chance to analyze, improve, and promote diversity on our bench. So my question to the member opposite is, will the member opposite support this measure in the bill, this added transparency, and this important step forward for increased diversity on our bench? Thank you.
Back to the member from Oshawa.
Thank you very much. And we have talked about this back and forth around the room. I acknowledge that there was an earlier proposal that, as the members across have said, the Attorney General has brought back a different version. My fingers crossed that it does indeed what this government has said. Because when we look around the community, we do recognize that we need more folks on the bench, we need more folks in the justice system that reflect the realities of the communities that they serve. So, if more diversity comes from this change, we will be appreciative of that. However, if more partisan or politicization comes from this, we got a problem. So the concern, and we've heard from different stakeholders, the concern that where we started versus where we are now, we still have a lot of people watching and waiting and hoping that it does indeed lead to diversity and not to increased politicization, which I wouldn't put it past this government, frankly. Thank you.
Thank you. The next question, the member from Brampton North.
Thank you, Mr. Speaker. I was going to ask a question about land tribunals, but I want to stick with regards to legal aid because it's still not getting an answer from the government. I asked some questions about legal aid, and they would give me an answer which would be surrounded in legalese, or they just wouldn't answer the question. So I'm not sure what they have against legal aid and legal aid clinics. But my question to the member, my colleague, as we know, legal aid system is, as we know, in Ontario, the bedrock of the justice system. Many people, low-income people, even people in my riding of Brampton North, they access the legal aid clinic. So I'm certain that this government, when they were putting forth proposals, they must have had received recommendations and advice from stakeholders. Please. So my question to the member is, why do you think that this bill doesn't address anything with regards to legal aid?
The member from Oshawa.
I don't know. I don't. And this is the thing. We've talked in this room about, legal aid and the legal clinics and, splitting hairs about where is being cut, where the cuts are being felt. The cuts are being felt across communities. And that's the bottom line, that the Durham Community Legal Clinic, as they said by their, in their own statement, that they only suffered about 1%, but because they deal with other clinics that lost more, everybody's feeling the pressure. So every opportunity, the member across said that this is the third justice bill that's come before this House. Well, I want to see legal aid. I want to see funding. If we're going to download all of this responsibility to them, where's the support for them? Because you have to appreciate what they do.
Conclude, please.
Everybody's office, including mine, including yours, including theirs, uses legal aid on a regular basis to support the constituents that we all say that we care so much about, and I hope do. Thank you.
Thank you. The next question. Member from Durham.
Thank you, Speaker. I just want to understand what the member opposite's referring to when she says we're downloading responsibility on legal aid clinics. There's nothing in the bill that does that. We're simply allowing those who want to have a someone that can attend virtually, witness the execution of their will, to allow for that, if they want. If they want the person there in person, that's allowed too. So are you in favor of the proposal, or are you against the proposal?
Back to the member from Oshawa.
So when you've got folks who are in the margins who we've talked about at length on this side, who will not be able to avail themselves of technological tools, you're not giving them an additional opportunity. The member opposite has said that there's a choice for other people. When I'm talking about downloading the workload onto the legal clinics, that's also their perception. So if we're asking the legal clinics how they feel about this, there is an additional amount of work that's going to come to them because more people are probably going to make this choice. And if the legal clinics who have access to the virtual conferencing software or whatnot, the tools that they have, they're going to be doing a lot of this work, and there isn't money that goes with it to staff them, the costs for setting up computer systems or cleaning or responding to questions, the legal staff that will go with this. You're bringing in a bill that has a truckload of changes, you know, specific if it's Schedules 8 and 9. Who's going to answer the phone when everybody wants to know more? Give them more resources. Talk to them, find out what they need. Thank you.
Well, we don't have time for another question on this one, so we have further debate. I turn to the member from Ottawa, Vanier.